Ready? Start. To give an exhaustive list of myriad kinds of cases wherein such power should be exercised. Stop. Where the allegations made in the first information report or the complaint, even if they are taken at their face value and accepted in their entirety, do not prima facie constitute any offense or make out a case against the accused. Stop. Where the allegations in the first information report and other materials, if any, accompanying the FIR do not disclose a cognizable offense justifying an investigation by police officers under section 156 of the code, except under an order of a magistrate within the purview of section 155 of the code. Stop. Where the uncontroverted allegations made in the FIR or complaint and the evidence collected in support of the same do not disclose the commission of any offense and make out a case against the accused. Stop. Where the allegations in the FIR do not constitute a cognizable offense but constitute only a non cognizable offense. No investigation is permitted by a police officer without an order of a magistrate as contemplated under section 155 within bracket 2 of the code. Stop. Where the allegations made in the FIR or complaint are so absurd and inherently improbable on the basis of which no prudent person can ever reach a just conclusion that there is sufficient ground for proceeding against the accused. Stop. Where there is an express legal bar engrafted in any of the provisions of the code or the act concerned under which a criminal proceeding is instituted to the institution and continuance of the proceedings, and or where there is a specific provision in the code or the act concerned providing efficacious redress for the grievance of the aggrieved party. Stop. Where a criminal proceeding is manifestly attended with malafide and where the proceeding is maliciously instituted with an ulterior motive for wreaking vengeance on the accused and with a view to spite him due to private and personal grudge. Stop. Para. Inherent power given to the High Court under section 482 CRPC is with the purpose and object of advancement of justice. Stop. In case Solomon process of court is sought to be abused by a person with some oblique motive, the court has to thwart the attempt at the very threshold. Stop. The court cannot permit a prosecution to go on if the case falls in one of the categories as illustratively enumerated by this court in State of Haryana versus Bhajan Lal. Stop. Para. Judicial process is a solemn proceeding which cannot be allowed to be converted into an instrument of oppression or harassment. Stop. When there are materials to indicate that a criminal proceeding is manifestly attended with malafide and proceeding is maliciously instituted with an ulterior motive, the High Court will not hesitate in exercise of its jurisdiction under section 482 CRPC to quash the proceeding under category 7. Stop. The criminal prosecution can be allowed to proceed only when a prima facie offense is disclosed. Stop. This court has observed that judicial process is a solemn proceeding which cannot be allowed to be converted into an instrument of oppression or harassment. Stop. If High Court finds that proceedings deserve to be quashed in parameters, High Court shall not hesitate in exercise of jurisdiction under Section 482 CRPC to quash the proceedings. Stop. Now we revert back to the allegations made in the complaint under Section 498A and Section 4 of DP Act. Stop. Few facts have to be noticed before we look into the allegations made in the complaint in the above regard. Stop. The complaint has been filed by the respondent number 2 before the CJM Karnal on 10/5/2015, before which date the petition for divorce has already been filed. Stop.